Okay. One of the things that hit me is this. Judges are different. Federal judges have different ways of approaching things. My experience has always been this. If you're about to do something that is different, that is unique. Example, tomorrow we're going to be bringing in a 20-foot by 20-foot model on day 3 for an expert to work with way in advance of the trial. I'm going to tell the judge, we got a huge model. Your Honor, how would you like us to work this model into the courtroom? I explain it. But most judges, they like the idea of saying, yeah, it's my courtroom, I'll give you some guidance, and they appreciate that, and you still end up getting to do what you want. Most judges, in my experience, abhor surprises. What Sach is doing, though, is throughout the case, he's peppering the judges with demonstrative aids that are embedded in the complaint. When they file a brief in opposition to a summary judgment motion, all kinds of diagrams and charts and exhibits are embedded in the brief. Example, in a recent case, we get a trial order. And the trial order says each side will be limited to 1 hour of jury selection following the court's inquiry of the panel. The court will bring down, this is a multi-defendant case, a building collapse. The court will bring down 24 jurors. I'll have 24 challenges for cause. So what do you have to do? Motion to extend the time allowed for attorney voir dire. Motion to expand the size of the veneer panel. You don't do that and bring it up at the pretrial conference. When you get the trial order and it says the case is going to trial 10 months from now, and the pretrial conference will be 9 months from now, the second you get the trial order, you file those motions, and you must set them for hearing. Think of what happens in so many cases. I'm sure it's happened to some of you. You file motions in limine because the court says motions in limine need to be filed prior to the pretrial conference, as an example. So in the mind of most plaintiff lawyers and paralegals and legal assistants, if the pretrial conference is on January 15th, that's the day we should file the motions in limine. Well, then you call up and say, we need 2 hours of hearing time. The judicial assistant says, the judge has no time. The judge says, you should have filed these long ago. Judge, your order says yeah, but we don't have hearing time. We had a judge in a case, a lawyer called me up going crazy. He said, the judge just entered an order saying we've waived motions in limine because we didn't get hearing time. All right. With that, by the way, one other quick thing. Again, you cannot get a judge to say yes unless you ask the judge for permission to do something. I hear lawyers all the time saying, well, we don't have jury selection in South Carolina. In my state, we're not allowed to ask questions. The judge does it. I'm in federal court. You can't get it. No, you've got to ask. We had a case that Todd and Dino Colombo and I did up in West Virginia. We had a federal judge, and I told the judge at very early on hearing, Judge, I know we're a long way away from trial, but one of the things that we would request of the court is permission to conduct attorney voir dire. And this judge, he was great. He looks at me, he starts laughing, he goes, you expect you can do jury selection better than I can do it? I go, no, I'm not saying that, Judge. I'm just saying we've been in all these depositions and we would like that. He goes, I'm going to let you submit a motion. And then he says, Mr. Romano, I don't want some motion that's all lawyer talk. I want evidence. I said, yes, sir. So we filed motion to conduct attorney voir dire, and we attached to the motion and the brief peer-reviewed articles from PhD trial consultants and have affidavits from them. And then we went and got 2 former federal judges and got affidavits from them. So we go to court, I'm all set. We're going for the hearing. Here's what the judge says. He says, I'm ready to rule on your motion. I said, well, Judge, we haven't argued yet. He said, you're not going to need to argue. I'm ready to rule. He said, the motion to allow attorney voir dire is denied. He says, you know why it's being denied? I said, no, Your Honor. May I ask why it's being denied? And he laughed and he said, yep. He says, because I know you, Mr. Romano, and I know that if I grant that motion, within a few seconds after I grant it, you're going to spread it all over America, aren't you? And I said, I probably would, Judge. Yes, I would. And he laughed. He says, so I'm going to deny the motion. So there'll be an official order saying your motion is denied. He said, but then I'm going to tell you what I'll do. When jury selection starts, I'll probably spend a few hours because there are a lot of defendants. It's a complicated case. And then I'm going to turn it over to the plaintiffs. And you can go at it. I'm not going to even put a time limit on you. And then I'm going to give the defendants equal time. There's like 7 defendants. So one of the guys stands up, says, so Judge, if Mr. Romano takes 3 hours, each of us gets 3 hours. He goes, no, that's not how it'll work. If the plaintiff side takes 3 hours, the defendant side gets 3 hours. And that's how we're going to do it. So you all are going to have to coordinate. So that's what we did. All right, this is what I want in a trial. I would love to come out of jury selection with this. You've all seen it on TV. They hit the golden buzzer and the things go flying. And it all starts with this. It's a filter is going on when you're in jury selection. They're looking at you, they're watching you. But you are telling a story. Sach probably told 5 stories. He's already into storytelling in jury selection. You think of this? Think of every movie you've seen recently. Think of every one of these new series you've seen. Think of even the comedy shows and how each one of them starts off. And then take a look at this book. You need to please consider getting this book, The Anatomy of Story. Because jury selection, I don't care what's happening, you're telling a story. Authenticity is the second cousin of credibility. It might be the first cousin of credibility. When you are authentic, you are genuine, you are real, and your evidence is real, your witnesses are real, your clients are real, the jury wants to embrace you, which is why all of these trials are about credibility. So it starts with jury selection and exactly how you're approaching it. What Sach told you is so important because here's what happens. Think of how many speeches you've been to. You go to a luncheon and there's a speaker. And the speaker starts off with, okay, so there are these 3 guys, and tells a joke. Well, I don't know about you, but when I'm sitting there, I go, I'm about to listen to 30 minutes of BS. If this guy thinks that he's got to start off with a joke, I don't need a joke. I want your message. I want to know what you're here for. The studies that I think Sach is talking about were done by Harvey Moore, PhD sociologist. And he did repeated focus group sessions where the judge in these sessions would say, you ready to begin voir dire? And the lawyer would come up. Hello, ladies and gentlemen, my name's John Romano. I'm with this firm and I do all the things. And what happened is, Dr. Moore in his mock trial, each juror has a computer device in his or her lap. And if they agree, they like what you're doing, they move it to the right. If they disagree, they move to the left. And you can see when a lawyer starts off voir dire with all of that type of nonsense, the jurors think it's total time wasting, as Sach says, the sales pitch. Instead, get up and go right to it. Same thing in summation. You don't get up and say, we appreciate you. Thank you for your jury service. you start losing them. You may filter that in at some point in the summation, but don't start with that. You go right into it, like an opening statement. You go right into the story of the case. There was a contest. This goes back years ago. And the contest was, who can tell the greatest story with the fewest words? And it was a national contest. Here's the story. Six words. Orphan shoes. For sale. Never worn. Economy of words is vital in what you do in jury selection. Being articulate means getting a point across with the fewest words. Always be thinking that in jury selection, you are continuing that voir dire throughout the trial. I'm going to hit these quickly because I want to go into some of these visual aids. The components to the story, it starts in jury selection. The magnet effect, that's where you draw people in. We saw the James Bond movie recently. What does it start off with? Not who's starring in the movie. There's immediately a chase and people jumping off roofs and you're like there. You're in the movie. It's like you're with James Bond being chased and your heart's pounding. At least my heart was pounding. Anticipation. This is such a key. I was telling some of the folks yesterday about, I love telling stories to the grandkids, and I used to love doing it with our kids. And I tell them this one story, and I'd like to make up stories. I don't even know where we're going when we start. And I told them this one about the magic land of Winnemututu and the castle and all this. And then as we get down, I say, and then we go through the forest, and all of them are riding triacorns, and I describe the triacorns. Triacorns, there's no unicorns. Triacorns have three, and they're like, three? And then I said, and then we came to the river, a river known as, and you look at them, and they're all, I go, it's called the Milkshake River. It flows in 7 flavors. Okay, you ready? Little May goes, I know one of the flavors. They're anticipating. I don't care whether you're dealing with 4-year-olds, 20-year-olds, 70-year-olds. We anticipate it when it's a great story. You're engaged in the anticipation. Make it entertaining. You got to do that in the courtroom. And I'm not talking about some kind of a song and dance act, but making it to where you've got them going. Create word pictures. Mr. Romano, are you ready to begin your opening statement? We bring to you a case this morning unlike the normal course of human events. We bring to you the case of a young mother and father standing on a hillside under a tree at the gravesite of their little girl. That's a quote from an opening statement I gave in a trucking case. Are you ready? June of 1978. Okay? I got that from a lawyer who suggested those words. When the trial was over, one of the jurors said, I was haunted throughout the trial by the vision of the family at the gravesite of their little girl. You can do that. You create word pictures. You start doing it in voir dire. You do it in opening statement. A great story is you engulf the listener's imagination. Another one, easy to grasp and understand. The complicated Hollywood movies most of us don't like. Now, every once in a while, there'll be a movie where nobody understands it, and somebody will come up to me and go, yeah, I really like the point of that movie. I go, oh, for God's sakes, you don't have a clue. Nobody knows what it was about. It's like, do you know that the musicians for over a period of 60 years, rock and pop and country and western, they all had a vote. What is the single most iconic song from 1960 until 2020? You know what they voted on? Any guesses? Led Zeppelin's Stairway to Heaven was number one. Listen to the words, and you go, what in the world is that all about? And it's difficult. Everyone has an interpretation. Ending with a surprise which was worth the wait. Maybe for those of you who remember the movie The Sting, all right, with Paul Newman and Robert Redford, the ending was like crazy phenomenal. And most of us, we like those endings. All right. You remember the debates? For those of you who aren't born yet, I know that you know about them. The bottom line was the people that saw it on TV, the first one, they thought John F. Kennedy won. The people who listened to the same debate on the radio thought that Richard Nixon won. And they did give consideration to who could afford a TV, who could not afford a TV, and all of that. Same thing, all of these debates. Who's winning these debates? Why are they winning these debates? Well, there's your reasons. 70 million viewers in the first debate. And it was judged that John F. Kennedy won. Second and third debate, only 20 million people watched. You know why? They go, I don't need to watch this anymore. I already know what I'm going to do. Okay? Clearly, the polls showed Nixon won the second and third debate. Fourth debate, a draw. All right. Some things to consider in jury selection. I don't know if any of you have ever used paddles, but when you have a bigger case and a lot of jurors, and I've had, we did a commercial case against two very famous athletes, and there were two panels brought in a huge courtroom that's a ceremonial courtroom down in West Palm Beach, and each panel had 150 jurors in it. And jury selection took us into a third week. But one of the things you can do in a case like that is on some of the more generic questions, and you do it by saying this will help the court reporter, it will help the clerk, and Your Honor, it will assist the court. You might say a question like this: how many of you have ever previously served on a jury? If so, hold up your paddle. Let's assume you think that's an important question. Well, if you got 150 people, you're going to have 100 people hold up the paddle. So there are two ways of doing it. You can then say, okay, let's go down. Now, I don't want to do that with 150 people. But what one judge has allowed us to do in one case, can we take a snapshot of the group, give that to the court reporter? Then the court reporter will be able to do that. We'll have it in the record when we know it's going to take a few days. So the paddles simply say Jenkins number 17. So whenever something happens, Ms. Jenkins holds up her paddle, we know it's Jenkins 17, and we're not fiddling through notes. And that is a new thing that a lot of the trial consultants are doing. But don't just show up with your 150 paddles or 25 paddles or whatever. Talk to the judge about it early on, not at the pretrial conference. Don't save anything important for the pretrial conference. If it's important, you want to handle it way ahead of time. Another item, Rapid fire, agree, disagree. What do? You get into federal court. This has happened to us. And the federal judge says, here's what I'm going to do. I'm going to pick the jury. And then, Mr. Romano, I'm going to grant your motion, and here's how it'll work. Whatever time I take when I'm done, plaintiff gets 15 minutes. I say, Judge, please. Judge says, I'll take that as a renewed motion, denied. I had that happen just recently. I know this. In that 15 minutes, what is my goal? It's a mistake if I think to get them to like me, to get them to respect me, to establish rapport. No. I must work to identify the plaintiff haters. And it's going to be tough in 15 minutes because the judge isn't going to try to, erect challenges for cause. So we create a board that we would put in front of the jury here, a big board here, and it would simply say this. An example would be pain and suffering damages are appropriate under certain circumstances. Let's just say that's the question. By the way, I wouldn't put the question together myself. I would always have a jurist, psychologist, or sociologist do it. Then, assume we have 36 jurors in federal court. I would then say to each juror, and I'd have another board that says, strongly agree, no opinion, and I'm sensitive, Satch, to not letting them get away with that. And then disagree, strongly disagree. And then I would start off with this. Folks, I only have 15 minutes. I'm going to get right to the point, and we're going to do something that it seems somewhat rude to have to do it this way, but we have to move rapidly through this. So I'm going to have these questions, and I'm going to go through each one of you. I only have 2 questions. So, Mrs. Smith, as to this, here's the question, and then I show the little sign, and I go, what I want to do is just have you say, pick one of these categories that you feel exhibits your belief. All right. Ms. Jenkins, go. Strongly agree. Mr. Smith, disagree. Ms. Jenkins, no opinion. And you go right down. All right. Let me move to my second question. I do the second question, and then I say, ladies and gentlemen, I appreciate your patience with me. Your Honor, I have no other questions. That's it. And by the way, if I'm at 11 minutes and I have 4 minutes left, we don't start improvising. Okay? All right. Another item, photo of sympathetic, in a sympathetic situation. Back in, are you ready? 1984, I was trying a DPT vaccine case, which was interesting. It had similarities to a med-mal case that I just tried this past August. In the vaccine case, I finished jury selection, and I took like 2 days. The defense lawyer gets up, and as he walks up, he's holding like a 5-foot high that he pulled out, hadn't shown us, so it was a surprise to everybody, photograph of our client, who was a horribly brain-injured little child, about 4 or 5 years old at the time of trial. And it was like, do I object now in front of everybody to him showing a photograph of our client? Anyway, I decided not to. So he just walks and he stands there and he just holds the photograph, and I'm dying. because I know where I think he's going anyway. And he said, this is Mary Lynn Sanchez. This case, in many respects, is going to be about this little girl, and I need to know this. What do you see when you see that picture? And I went, I have underestimated this guy, because this is a brilliant move. So I learned a lesson. And the lesson I learned is, if ever I have the reverse of that, for example, a drunk driving defendant going 90 miles an hour ends up a quadriplegic, but also kills two people where we represent their family. What happens when he comes in his wheel? What happens? Some of the jurors go, oh my God, can't we just shut this whole thing down? So I've done that, where I bring in the photograph. So be thinking about how you might use something like that. When I've done it, by the way, I have told the judge, not exactly what I was going to do, but that we may use some photographs where we need to identify witnesses, see if you know, like some of you don't know the name of the doctor, but here's the doctor's picture, do you recognize her, that sort of thing. Another item, I have a 12 question board. We can take a snapshot. It varies from trial to trial. By the way, when you are using boards or exhibits, always remember the psychologists tell us coloring is so important. There are books on the psychology of coloring and lettering. And if you are just going to have, like, there's a reason a stop sign has a certain color background and a certain color lettering. There's a reason when you go on to military bases, certain things that are like super important, they are usually red with bright yellow lettering, and that means do not go by this sign and not pay attention to it. Where other signs, you may not. The 12 question board has all of the questions. So my preference in jury selection is to have the judge ask the generic questions, like how many children do you have, where do you work, and all that. Some judges do it. If they do, then it gives me a way to, the opportunity to really focus on what I need to, and then I can go back over those things that are important. Some judges say, no, I'm turning it over to you. You got so much time, do it. So I want to have the board. I don't want to have to keep looking down, reminding them of, here are the questions I'm going to first go through this and ask each of you. And it is, how many children do you have? What is your job? What is your spouse's job? As to your parents, what did they do? I want to know that. I want to know that. I want to know in a medical malpractice case, Grandpa was the greatest doctor in the world. I want to find that out. Very important. And then that way it moves a little quicker. Because if you have 60 people in the veneer panel, and you say, okay, let me start with juror number 1. I'm going to ask you all 12 of these questions. The juror back here is going, are you kidding me? They don't have a better way to do this? And there are better ways. One is a juror questionnaire. Some judges allow it, some don't.